Hello students, again it's HB Dlamini with module 15, Public Law and 6. The topic is aids in the interpretation of the law. Aids in the interpretation of the law. Public Law and 6 book by Kruger. So for you need your book, Public Law, just for reference purposes. The aim of the aids in the interpretation of laws is to explain the fundamental rules with regard to the interpretation of laws, right? We've got the internal aids as well as the external aids, okay? All what you must know about these internal aids and external aids is that the internal aids are more about everything which is in the text. Let's say you are holding an act in your hand, right? A big book in your hand. So the internal will deal with everything in that law book you're holding, right? That legislation you're holding. On the other hand, the external will deal with things which you'll take from somewhere else, like you may take another legislation from somewhere, you may copy it from the Constitution, you may get the prescripts which tell you what to do when interpreting from outside the text you are holding. Okay? So the internal aids are as follows. It's legislative text in another official language, original legislation, and another legislative text, the preamble or preface, the long title, heading to chapters, paragraphing, margin, headings, and punctuations. Okay? As far as the legislative text in another language, that one deals with the text in that previously, before 1994, we had two official languages. It was English and Afrikaans. And after 1994, we had 11 languages. Even now, we've got even 12 because there's a sign language now. It's an official language, right? So now, in whatever language the act is written, the language could be used to clarify unclear legislation. Okay? So all these official languages, the act may be written in Xhosa, in Zulu and all that, but all those languages must be signed. All those acts must be signed. All those copies of the act must be signed by the president. Okay? So original legislation and another legislative text, original legislation must be signed by the president, as I've just said. There's another, the preamble. The preamble states that the circumstances, it states the circumstances or background and the reason for the legislation. The preamble is usually placed after the long title. It portrays the true meaning of the legislation, also identifies the objects of the act, etc., etc. Okay? But the preambles, as it is, can give an indication of the intention of the legislature. As I said in module 14, that the intention of the legislature is to enroll. Okay? Let's move over. There's a long title, the headings, the chapters, sections, paragraphing, and the addenda, right? Those are all parts of the internal, right? Now let's start with the external one, the external aids. our constitution is the supreme law of the land, and therefore the most important and it's the most important act in our interpretation, because we must always follow the constitution, because any act which is against the constitution is invalid and may be declared invalid and null and void, right? Okay. Another source of another external aid is the source of the article, where it comes from, right? Another one would be the preceding discussions. Those were the debates before the promulgation of the act, right? The commission reports, what did they submit regarding that new act which had to be promulgated, right? Peripheral circumstances surrounding the promulgation of the act. In other words, it's peripheral circumstances or surrounding circumstances which led to the promulgation of the act, right? In that one, there are questions which are referred to as mischievous questions whenever you're dealing with those circumstances, right? Those are the circumstances that the courts must consider. So the first one, they are in a form of questions. The first one is, what was the legal position before the legislation was adopted? Second one, what was the mischief not provided for by existing legislation or the common law? What remedy or solution was provided by the legislature to solve this problem? And the last one is, what was the true reason for the remedy when they were remedying the act? Okay? So we also have the dictionary and linguistic meaning, explanatory memoranda and all that. Please do read all this. It's simple and self-explanatory. That is the reason why I decided not to confuse you with the notes here, because the syllabus only needs you just to know this, right? You also have to know the earlier and later law, the ingrained customs and the textbook. But please read the Interpretation Act 37 of 1957. I'm sorry, the instead of 1957, it's written 157. Please correct that. It's 1957. Please read that act. It's on page 104. So in conclusion, the Constitution 108 of 1996 does not specifically prescribe an approach to statutory interpretation, but stipulates that when interpreting the legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. So, with the Constitution, we rely on the Constitution as the supreme law of the land, that is the law of South Africa. Anything which is counter to the Constitution may be declared invalid and null and void, and declared null and void. So good luck with your remaining tests and exams, and please, we're praying for the coronavirus to be a thing of the past, and please study African Child. We believe in you. Amandla.